Mr. Keneally, please call the first case.
SJC-12908 in the matter of an impounded case.
All right. Ms. Doherty. Oh, you're on mute. You're still on mute. We can't hear you. Oh, there you go.
Okay,
Great.
thank you. Good morning. May it please the court, Happy New Year. Welcome to the new justices on the court. I'm Elizabeth Doherty. I represent John Doe, the plaintiff in this matter. Just to start out, the purpose of the sex offender registry law is very clear from its enactment, that it was to protect against sexual offenders and to prevent sexual victimization, in particular to protect vulnerable members of the community, including minors, from sexual offenders.
I want to just interrupt you and ask you about some scenarios, and you're very interested in brief, okay? So the two scenarios that come to mind are cases like your client's case, where suppose there's a car theft and the person who steals the car doesn't know there's a baby in a car seat and the parent is negligent to leave, and they steal the car and they go, oh geez, there's a baby in the back seat. That's a kidnapping, right? Yes. That's similar to your client, kind of. The second scenario is, I'm thinking of the Sakari and the Janes cases from way back, where someone kidnaps a child intending to have sexual abuse, and suppose in Sakari and Janes, the police stop the car before anything bad happens, and we don't know, they don't get to sexually abuse the child. So those are the two polar extremes, I think, of these cases. The result you want us to reach, the due process argument, is all cases, including that Jane Sakari kidnapping with intent to sexually abuse, would not be covered under the statute, or would it, or is there some result that gets us to the second scenario being covered?
Absolutely. I believe that, so the kidnapping statute, when it, at the beginning, there was just one paragraph of kidnapping. Everything was kidnapping. And its evolution through the years have been that they've been added a number of clauses, a number of different alternative ways in which to commit kidnapping. The third paragraph would cover that type of scenario where there, in fact, one of the crimes that's specified in there, I believe, is assault with intent to rape.
Well, that's different though, because in some of the cases that discuss this, they say if there's another crime, there's kidnapping plus assault with intent to rape, you already have a registrable offense with the assault with intent to rape. I'm talking about standalone kidnapping, as opposed to some type of sexual behavior or something of that sort.
Well, I mean, I guess I would back up and say that in order to be, so the sex offender registry, sex offense under 178C, covers a number of offenses. Every offense that's in there has some sort of sexual component. And in order for this to be a sex offense under that, I would concur that, I would argue that it has to have a sexual component. There are many violent, even serious, even violent crimes against which, and against
right.
things against.
The question I'm asking you is, if we reach your result, what do we hold? Do we say that this crime, right, cannot be enumerated because it violates due process? Or do we say something like this crime unless there's additional proof? That's where because that's the Florida case held that way with additional proof. And I'm asking you, how far are you asking us to go in your case?
I think that there has to be proof of some sort of a sexual component in there in order for it to be considered a sex offense.
So you want us, all right, so you want us to do what Florida did and read that into the statute?
Well, again, I think that this court can construe the statute that is 178C, a definition of a sex offense. I think it can construe it in a constitutional manner if you specify that the offense that is a sex offense is the third paragraph of 265-26.
Again,
I think that
But-
construction avoids constitutional infirmities. It gives weight, or it interprets the statute the way that the legislature would have thought that this statute has to be construed to involve a sexual offense, or a sexual component rather.
right, so let me ask you probably my final question. As I go through your brief in Ms. Nixon's brief, and I'll ask her the same question, can you give me a sense of the scorecard? So there are 42 states who have enacted the statute after the federal statute. I know that there's a federal court, I think it was New Mexico, there's the Florida case, and maybe it's a trial court in Ohio that have gone the way you ask us to go. Is that all the cases that have held this to be unconstitutional, or am I missing something?
No, the U.S. District Court, which is standing, hasn't been challenged. Eunice versus Robinson, which I cite in my brief, found
Was that the New Mexico case?
No, that was New York.
New York, I'm sorry. Okay,
Yes.
so
That's cited in my brief, and that's a U.S. District Court case.
okay, I think I missed that. Okay, thank you.
Yeah.
Did I miss any other ones, Ms. Doherty?
I think that in my brief and in Ms. Nixon's brief, I think that we have, I wouldn't stake my life on it, but I think that those are the ones that are identified.
Thank you.
The most recent one, as I say, was 2019, and that was Eunice versus Robinson, and that's in my brief.
Great, thank you. Those are the questions I have.
Okay.
Doherty, I want to talk about whether or not it's a legitimate legislative concern to link childhood sexual exploitation with concern about kidnapping children. Because if we're dealing with a substantive due process issue and whether or not this circumstance shocks the conscience, really, one of the issues we're looking at is it reasonable for the legislature to say, we have a concern whether, to go back to Justice Gaziano's point, in these particular facts, it's actually come to fruition that it's clear that there's an intent for sexual assault. But we just are concerned that when there's kidnapping of children, there's a serious concern about childhood sexual exploitation. Why does that link raise a substantive due process concern?
Well, certainly protecting children from sexual harm and sexual predators is a reasonable legislative objective. But in this case, where there is no evidence, the plea judge, it's undisputed that there was no sexual component to this. That's not a reasonable relation to identifying kidnapping without a sexual component as a sex offense. I wasn't sure.
Just before you finish answering Justice Lowy's question, because I need to understand one fact to understand your answer to his question. How did this crime terminate? How did it end?
So the facts that came about that came out of the plea hearing is that this child was in the stairwell of her apartment building, and the plaintiff was in the stairwell as well. It seems to be undisputed that he was suffering from a mental episode at that point. She came along and he punched her and whatever, and then they came down the stairway, and he was bringing her, I believe, to the lobby. And from there, whether he let her go or she escaped from him. So it terminated in the lobby.
It terminated in the lobby, and she may have run away.
Or he may have let her go.
Okay, I
We're not
understand.
sure.
All right. I'm sorry, Justice Lowy. I didn't mean, I just wanted to get that in my mind as far as the ending of this escapade and to better understand the answer to your question.
That I was going to say, just to finish up, the facts of that are in the record appendix. The best recitation of them are in the plea.
Right, I read them, but I just want to
Okay.
make sure I understood what you understood.
Okay, okay, thank you. Getting back to your question, Justice Lowy, the link between, as I suggested in the both in my brief and in more detail in my reply brief, the link between child kidnapping and child sexual assault is very questionable. The research and the studies are questionable, but this seemed to come about. It was a
Well, how questionable are they? I mean, I'm just looking at some of the stuff cited. 2/3 of the child kidnappings involve sexual offenses. They've excluded kidnappings, intra-family kidnappings, which are the ones that we would assume. I mean, I can imagine there's the Raising Arizona, whatever that movie was, where they're stealing the child to have a baby, but there are very few of those. So why isn't there an evidentiary, or at least a empirical basis for concluding that kidnapping has a sexual component in this type of case?
Well, I mean, I would dispute, and I think I did in the reply brief, that 2/3 number is not being valid. That some of it, as I described in the reply brief, some of the data collection was extremely questionable. And
so isn't that really an argument that one might make to the legislature, that to say to the legislature, you know what, this is too big of a net. 2/3 is actually not accurate. It's more like, I don't know, 1/3. But isn't that an argument for the legislature in looking at the constitutionality of the provision? Don't we have to look at whether or not there's a rational basis for a connection, not the data underlying it and questioning whether or not it's 2/3 or 1/3, but is it a reasonable basis to have as a gating issue that the sexual offense is kidnapping, which is correlated in some way to sexual abuse, and then have the hearing officer examine whether in fact this particular doe should register? Why isn't that a reasonable scheme?
this, a couple of things. This particular doe, the hearing officer did not examine in any way whether there was a sexual component at all. As I say, it's completely undisputed that there was no evidence of that. But just to sort of back up with respect to sort of the link between child kidnapping and child sexual assault, all of this legislative, all of these sort of research studies came about in sort of the adoption of SORNA, of the federal statute. We haven't, in this state, we've not had that. I don't know if we had SORNA. I think that there would be constitutional problems in that Doe 8725 and Doe 1211, that there would be problems in, that you're asking somebody to register where there's no evidence that that person poses a chance of sexual recidivism or sexual harm.
But that's not the case here, right? I mean, it seems like you're collapsing the statute with the specifics of your case. And you haven't really explained why there isn't a rational basis for having kidnapping be a part of the statute. And I understand that you're saying that in your client's case, there was no sexual component of that particular kidnapping, but that doesn't mean that the statute's unconstitutional. They looked at your client, right, and looked at all the circumstances, and the hearing examiner found that he was a risk to commit sexual crimes.
There was no evidence, though, that he was posed a risk of sexual recidivism or sexual harm.
Well, you understand that SORB is going to challenge that. They're going to say, wait a minute, she ran away. You don't have to throw your common sense away. This person already committed a very serious sexual assault on somebody else according to SORB. I understand the verdict. And they are going to say, going back to Justice Gaziano's point, the kidnapping stopped before there was an opportunity. And what do you think the sexual predator was going to do if it didn't happen with a young girl of the same age? Their assumptions are different than yours.
Well, I guess I would just sort of back up with respect to the consideration of the conduct of which he was acquitted. I mean, I would argue that without a sexual component to the index offense, you shouldn't even get to the hearsay evidence of acquitted conduct. I mean, it would be as if you had a trespassing charge that, you know, that was the valid offense, and then you sort of came back and dredged up acquitted conduct. You don't, you can't consider, I would argue, you can't consider this hearsay evidence, not even getting to the reliability of the hearsay evidence without having a jurisdiction, without having a sexual component. And so, I mean, every other case that you look at where they're considering hearsay of other conduct, the offense that is the index offense has a sexual component to this. This is, you know, very unfair in that, as I say, they're dredging up from, you know, from long ago, a charge that, or not long ago, but charge of acquitted conduct in order to sort of make the index offense into a sexual offense, which is, you know, is very unfair on his part. Again, I would argue that this court can construe the statute in a constitutional manner by just making sure that the kidnapping offense that is that considers a sex offense under 178C is the third paragraph of kidnapping. You know, I think this is consistent with the legislative history. It gives the plaintiff in this case the benefit of an ambiguity, and it permits the court to construe the statute in a way that avoids constitutional infirmities.
I may have missed it, but did you say why it's why there's no rational basis here for the statute as it currently stands without?
There's no rational basis because it's very clear that the purpose of the statute is to protect against sexual harm, sexual offenders, and to protect minors and vulnerable members of the community against sexual harm. In this case, there's no sexual harm. And I would also say that, you know, the evidence with the link between child sexual assault or sexual harm and kidnapping, without that, there's no rational basis. I mean, particularly to impose, as this court recognizes, the onerous burdens of sex offender registration.
Does anyone have any other questions? Okay, thank you so much, Counselor. Attorney Nixon.
Thank you. Good morning, and may it please the court. Nicole Nixon, Assistant General Counsel, appearing on behalf of the Appellee Board.
Ms. Nixon, let me just jump to the chase.
Absolutely.
And I gave the two scenarios, one of the car theft and one of the, I guess I'll say the Sakari Jane situation where they're apprehended before anything even worse happens to the child. Is this an all or nothing situation, or is there a way to say that we find it a due process violation unless and until there's a sexual component, intent, or motive that can be proven?
I think it is an all or nothing conclusion in this case, because what we're looking at is the legislature's inclusion of this specific crime, kidnapping of a child, in violation of Chapter 265, Section 26.
I know you've read all the cases, but if you go to the Florida case, what they conclude is we hold only that under the facts of this case where the state concedes the crime contains no sexual element, it conclusively belie any sexual motive. The designation of the defendant as a sexual predator is unconstitutional. So that seems to hold open the door for a court to say that where there is a sexual motive, there's statements, etc., that would be an index, that would be a qualifying offense. True or not true?
I don't think it holds open the door. I think if you look at the Florida case specifically, it was a very narrow holding based on that specific set of circumstances.
Right.
And I think
And
the
that's what I'm getting
circumstance here.
is it possible to have a narrow holding, or is it all or nothing? That's, I guess, the question I'm inartfully asking.
I think it's an all or nothing holding in this particular case. If you look at the argument that's made here and what's being raised is really whether there's a rational basis to include this crime as a sex offense from the sex offender registry law. And in Massachusetts, and I think this is different from that Florida case where I believe in Florida, once you're convicted of a sex offense, that triggers the attendant registration requirements. There's no further hearing to determine whether somebody should be ultimately classified as a sex offender. And I think that's what makes this particular case different from that Florida case.
Okay, thank you. And let me ask you just maybe a last question. What Ms. Doherty cites, and there's a lot of case law in this state that, I don't know if it's unique or not, we're gonna have to dig into it, that emphasizes that what we're talking about is not criminal behavior. We're not talking about recidivism. We're talking about sexual recidivism and sexual dangerousness. Is that something that distinguishes Massachusetts case law and requires us to find a rational, not a rational basis because of that Massachusetts case law?
Well, I think that it's a little bit tricky. I think that certainly to have somebody be finally classified as a sex offender, the board has to prove by clear and convincing evidence that somebody poses a risk of sexual reoffense and a risk of sexual harm. That's undisputed. There's multiple cases that say that. But I think here that was done. But if you look at whether there's a rational basis to include this specific kidnapping offense as a sex offense under the sex offender registry law, I think there was certainly a rational basis to do that, where there is that link between a kidnapping of a child offense and sexual harm.
Can you give me your reasons why there's a rational basis?
Sure. I think if you look at the specific crime of kidnapping of a child, it involves forcibly taking away a child from the protection of his or her loved ones and isolates them, making them more vulnerable to sexual assault. In this type of specific crime, it's certainly reasonable for the legislature to include this specific crime as a sex offense to let the board or allow the board make an inquiry into whether offenders who commit this specific offense pose a risk of sexual reoffense and sexual harm to warrant a final classification. I think that's certainly rational, and I don't think that Doe's proven irrationality on this record.
Do we need the statistical evidence? Your sister argues, okay, they put in statistical evidence when they did the federal statute, but the legislature did not have is this a case where we have a statute with a legislative history that indicates someone considered the statistics on kidnapping? Or is that something we're just going to have to infer?
If you look at the legislative history of the Massachusetts sex offender registry law, there's nothing specifically in it that talks about consideration of the statistics that the federal Congress did. Mm-hmm. However, I don't think that's necessary to conclude a rational basis here and to conclude that the legislature rationally included this crime as a sex offense.
Are you familiar with the law review article cited in your sister's brief that refutes some of the statistics?
I am, and I think that's the opinion of the law review article's author, that attacks sort of the methodology behind some of the DOJ studies that the federal Congress had relied on in enacting the Jacob Wetterling Act. I've read the article and I understand the arguments behind that, but I don't think that this court needs to find that as conclusive proof that those articles and the research that was included within those studies is unreliable.
I'm confused though, just for a second. So the feds did an analysis that included some statistical review of how often this type of kidnapping has a sexual component. the state statutes modeled on the federal one, is that true?
That's correct. If you look at the legislative preamble to the sex offender registry law, specifically the 1999 amendments, it talks about including the amendments to the sex offender registry law to comply with the federal requirements.
Okay, so then can we, whether this statistical review was done really well or not, can we, when you get rid of the statistics, you make me nervous when you start sort of positing a rational basis without, you know, because someone takes a child away from their parents, they're more vulnerable to sexual assault. They're more vulnerable if that person is going to sexually assault them. I'm just not sure I follow this. Don't we need a statistical basis for this, whether you can piggyback on the federal basis or not? Don't you need that? I mean, you're running away from that. I just want to make sure I understand where you are on that.
Sure, and I'm sorry if my answer was a little bit confusing before. I'm not running away from it. I do think that the statistical evidence certainly shows and supports a rational basis. And if you look at the enactment of the Massachusetts statute, it's pretty clear that it was enacted to comply with the federal SORNA, Jacob Wetterling Act requirements. So I think that when you're looking at a rational basis for the Massachusetts legislature to do something, it had included this kidnapping of a child sex offense to comply with those federal requirements, but also because you can make the argument that where the federal Congress found a rational basis to show a connection between the kidnapping of a child offense and sexual assault, that the Massachusetts legislature would have agreed with that rational basis and included this crime as a sex offense as well in its own statute.
And can I follow up on just Discasio's first hypothetical too? So does our statute address the person who runs off with the kid in the back, not realizing the kid's there, by the second part of the analysis, that SORB has to decide whether something, I mean, you get in the game because you have the kidnapping, but SORB, if it realizes this guy's just a car thief who has no history with sex offenses, is that how we handle the first hypothetical, that we're not in danger of requiring someone to register in that context?
That's correct, Your Honor. I would say in that certain context where somebody runs off with a car and a baby happens to be in the back seat, that person wouldn't have to register as a sex offender unless something within their history or within the circumstances of the governing offense shows a risk of sexual reoffense and risk of sexual harm. So I think the statute does deal with that type of crime and those circumstances in that way, and would mean that somebody who committed a kidnapping for, say, stealing a car and the baby was in there, or for, say, a drug ransom type of situation where I think some of the other states' facts bore out, those people would not be required to register as a sex offender under the Massachusetts statute.
Except what if they had something in their past, a sexual assault that was they were accused of but acquitted of, and so they would now be in the position of facing having to register. Is that right?
I think that would be a closer question, Your Honor. Certainly in this case, based on the facts of the governing offense, as well as his acquitted charges, the board had determined that he had to register and be finally classified as a sex offender. And it really depends on the factual circumstances of the particular case.
Right. So I'm saying, what if it was the same underlying facts, in the fact is he got into this whole thing because he kidnapped a baby unintentionally.
Sure. I think that if that were the case and there was reliable and substantial evidence to show that he sexually assaulted somebody on another occasion, but he wasn't convicted of that offense, then yes, he probably would have to register and be finally classified as a sex offender, because the board would have shown a risk of sexual reoffense and sexual harm.
You want to address the funds issue? Because this guy's got some mental health issues, but there's a denial of funds for an expert to help. So where do we draw the line here on the funds? Because we've reversed, or at least the appeals court's reversed in certain contexts where you don't give expert funding, right?
Could you rephrase the question, Your Honor?
This guy's got mental health issues, and he's requested funds for an expert, right? and that was denied because it wasn't a specific enough request. Your regulation's pretty narrow about when you get these. So I'm just trying to understand how that's consistent with some of our cases where we've reversed for the denial of funds. So it's an open-ended question, but go ahead.
So I think that the denial here, first of all, was proper because the DOE didn't make a sufficient showing to show a connection between a specific mental health condition and his risk of reoffense or danger. And I think that the hearing examiner complied with the regulation, but as well as the case law in making that determination. In some of the other cases where the appellate courts have reversed a hearing examiner's decision to deny expert funds, the DOE in those cases had made a sufficient proffer of evidence. Here, all we have to show there isn't really even a diagnosis of a mental health condition. The only medical evidence that we have here to support DOE's motion was a one-page mental health note from the DOC. I don't think in these circumstances that's sufficient evidence to warrant the granting of a motion for expert funds.
Ms. Nixon, if I could change the subject for a moment and go to the hearsay issue.
Sure.
When the Sex Offender Registry Board is considering a sex offense where the defendant in the criminal case was found not guilty, should there be a requirement that the hearsay needs to be corroborated to some extent beyond the requirements of Commonwealth versus Durling?
I don't think so, Your Honor, and I don't think so because there's different standards of proof in a criminal trial and in the admissibility of hearsay evidence at an administrative proceeding such as this one. And I think that the burden or the admissibility requirements in an administrative proceeding such as this one are sufficient to protect an offender's due process rights in these circumstances.
Can I just ask how it works if someone's acquitted of sexual crime, then they don't have to go before the board at all?
That's correct. To go before the board, there needs to be a conviction of a sex offense as described in Chapter 6, Section 178C. So if somebody's acquitted of sexual charges, then they would not have to register, unless, of course, there's another conviction on their record which qualifies as a sex offense.
So basically, SORB gets a chance to look at it only because this other thing happened.
That's correct in these circumstances, yes.
Can I ask you about the hearing examiner's actual decision? You know, some of the factors that the hearing examiner applied, like factor 2, repetitive and compulsive behavior. The examiner said the petitioner engaged in sexual misconduct with 2 victims on separate occasions. Now, there isn't sexual misconduct with regard to the governing offense. So I'm wondering if we have to send this back anyway because the examiner misapplied some of these factors. Actually, all of the aggravating factors. That's just an example.
Sure.
There's nothing sexual about the governing offense.
There was no evidence to prove that he sexually assaulted the girl or there was a sexual motivation. I
or
think
even any analysis in the hearing examiner's decision as to that at all.
there was not. That's correct, Your Honor.
But yet the examiner is saying 2 victims of sexual offense, therefore apply factor 2. I don't understand that.
Sure, and I think if you look at the regulation and the regulatory language of factor 2, even if you take out that first victim, the kidnapping victim, there will still be evidence to support the application of factor 2, where he had sexually assaulted victim 2 on multiple occasions with opportunity and time to reflect on the wrongfulness.
Sure, but that's something that SORB, I mean, we can't apply that analysis. The hearing examiner has to apply that analysis. So we would have to send it back for the hearing examiner to say, you know, maybe you persuasively could argue that, but that's not something that the hearing examiner took into account. He or she is actually looking at the 2 offenses and saying, yeah, that's repetitive and compulsive.
Well, respectfully, I would disagree, Your Honor. I think if the court does find that there is sufficient evidence to support the application of a factor, then you don't have to send it back for the hearing examiner's review and analysis. And the hearing examiner did, I believe in her analysis of factor 2, talk about sexually assaulting victim 2 on multiple occasions.
What
is the legal authority for that proposition? Because we defer to the administrative agency, and now you're asking us to substitute our analysis, or what you're supplying as analysis, for the application of factor 2.
I'm not asking you to support or to substitute my analysis or the court's analysis, certainly. I'm just saying that when there's other evidence to support the application of a factor, the appellate courts have not sent back cases for a hearing examiner's review. That's all I'm saying. But certainly the courts defer to a hearing examiner's analysis of the application of the evidence and the factors.
Okay.
If
Any other
there are
questions?
If there are no further questions, I would rest on my brief at this time and ask that this court affirm the judgment of the Suffolk Superior Court. Thank you.
Okay, thanks so much.